Hey friends, I'm Jeffrey Rickman. I'm a Global Methodist elder serving in a very rural setting in northeastern Oklahoma. This is my channel, PlainSpoken, where I do a lot of different material. I've been doing a weekly series with TJ for 21 weeks now. This is episode 21 of the Transitional Book of Doctrines and Discipline series, and it's going to be the first episode where TJ's sitting at the table with me. Say hey to everybody, TJ.
Hey, everybody. It's weird being over here.
Yeah.
I can't like look at the screen, see which camera it is and make sure I'm in focus or look at the audio.
You
It's
have to
really,
just be fully available to me.
yeah, it's weird. I, I'm not in control right now and it's throwing me off.
We've got young Matthew over there at the control booth, hopefully going to be, well, it ain't a booth, it's a desk. Hopefully going to be switching between cameras at the right time and keeping track of audio levels. So say a prayer for him. It's stressful, and we're two mean men that are going to bark at him if he
Yeah.
does something wrong. All right, we have been doing this series, as I said, for 21 weeks, and we've covered a lot of ground. We're now in section 8, or part 8, which deals with the judicial procedures. And we discovered last week that it actually is in relationship with another document outside of the Transitional Book of Doctrines and Discipline, which is called Judicial Practice and Procedures, I believe. It's abbreviated JPP. So we considered stopping midstream today and just going straight to that because it's referenced several times throughout. I just made an executive decision. We're not going to do that. We're going to finish section 8 or part 8, and then we're going to go back and we're going to cover that whole document. Then we're going to finish the Transitional Book of Doctrines and Discipline, and then it was released just this week. I don't know if you saw this, TJ. There's a document that got released. It's another 10 to 15-page document on how we're going to do general conference, all the policy and procedure around that.
Yeah, I saw something about that, but I didn't actually look into it.
Yeah, Beth Ann Cook published it. She was the chair, is the chair of the committee responsible for putting the convening conference together in September. So that'll be the final thing that we do pertaining to. No, actually, I think we'll do a circle back around because the version that we're working with is from February of this year. But when we started this, obviously, this version was not around. There have been several amendments. So I think we're going to do a final analysis of whatever changes were made. And then we'll call that series to a close. But then there are probably going to be several amendments that I and TJ want to actually publish and we'll talk through. So that'll just be its own thing afterwards. So this is, before we get into it today, I mean, the whole reason we're doing this is because what's in writing matters. And a lot of clergy and laity in the United Methodist Church didn't have it in them to figure out what was in writing until it was too late. And we're hoping to avoid the same bad stuff in the Global Methodist Church. We need a much more educated populace than what the UMC was, and we can't get stuck in the same quagmire again. So that requires coming through this material as we're going to do now. So, TJ, anything else to be said before we dive in?
I don't think so. We're on paragraph 809, which is page 91. Last week we went over judicial complaints, administrative complaints concerning bishops, administrative complaints concerning clergy, and a bunch of other stuff. But this week, what are we on? 809?
809.
Judicial supervisory response.
The purpose of the judicial supervisory response is to, so far as possible, establish facts, consider circumstances and explanations, determine if there is an issue that merits action, and arrive at a resolution of the complaint that restores compliance and redresses any harms resulting from a violation. Processing of a judicial complaint shall be governed by JPP 4, which we'll read at a later date. If the respondent is a bishop, the supervisory process shall be administered by the chair of the Transitional Leadership Council or their designee. The supervisory response shall result in one of 3 possible outcomes, including the dismissal or resolution of the complaint or a referral to the Committee on Investigation. So there are 3 possible outcomes. It says dismissal of the complaint, resolution of the complaint, or referral to the Committee on Investigation. So dismissal is, this was stupid, get it out of here. They're not guilty. Resolution is, okay, there needed to be some changes made. We're going to make them and then dismiss it. And then the third would be, no, there's something here. We need to have an investigation. And so that's when it gets referred to the Committee on Investigation.
Yeah, this sounds kind of like we're equating it to our judicial system in the States, like a judge almost.
Yeah, this is a direct corollary, I think.
Yeah. Committee on Investigation, well, that might be something like a jury.
Yeah.
So, okay. Makes sense.
Yeah, that's a question worth considering because I don't remember if it comes to another group after the Committee on Investigation or if the Committee on Investigation is the group that it comes to. So I think that is detailed today. Friends, I'm hoping to cover the remainder of this section in 2 episodes, so we're not going to cover the whole thing today. But here, let's look at point 2. And this deals with suspension. To avoid harm to the church or ministry setting or to the respondent, the chair of the TLC, with the affirmative vote of a majority of the TLC, if the respondent is a bishop, or the bishop with the affirmative vote of a majority of the cabinet, if the respondent is clergy, may suspend the respondent from all ministry responsibilities during the supervisory and investigative process for a judicial complaint. The respondent retains all rights and privileges, including continuation of housing, salary, and benefits, while suspended from ministerial duties, provided, however, that they shall not interfere with an interim bishop or pastor appointed to carry out their duties while they are suspended. If the judicial complaint does not proceed to trial, the respondent's suspension must be lifted at that time. So this is dealing with suspension. If charges are brought, there's an investigation going on. There's a process for suspending them. It's not an automatic suspension that takes place anytime charges are filed. Once that situation is met in the TLC, then even while you're on suspension, they still have to pay you and maintain your benefits until you're convicted.
Right. I guess that makes sense.
Yeah, you don't want... So one of the principles of American judicial law is innocent until proven guilty.
Right.
That's just a good stance to take in general. You don't want a kind of witch hunt atmosphere where the moment a complaint is brought, that person is guilty.
Yeah. Makes sense.
Anything else to do with paragraph 809 before we move on?
Nothing jumped out at me. Okay.
So now we're going to do section 2, which deals with the investigative response. So this is once things get referred to the Committee on Investigation. So do you want to take us where we're going?
Yeah, paragraph 810, composition of the Committee on Investigation. Number 1, when respondent is a bishop. The Transitional Leadership Council shall appoint a global committee on investigation as provided in JPP 5. 2, when the respondent is a clergy person, each annual conference shall elect a committee on investigation to consider judicial complaints against clergy members of the annual conference in accordance with paragraph 612.5. Whenever the respondent is a layperson, in all cases, the pastor or presiding elder should take pastoral steps to resolve any complaints, which is JPP 4. If such pastoral responses does not result in resolution and a written complaint is made against a professing member for any of the offenses in paragraphs 808.2, the presiding elder, district superintendent, and the district lay leader, if any, shall appoint a committee on investigation consisting of 4 professing members and 3 clergy in full connection to serve only for this complaint. Both clergy and professing members must come from other congregations, exclusive of the churches of the respondent or the complainant. Committee members must be in good standing and must be of good character. The committee should reflect racial, ethnic, and gender diversity. 5 members shall constitute a quorum.
So they were kind enough to include for you the inclusivity thing there.
Yeah.
So I found it odd that so much more language was given to the trial of a lay person, but then it seems that there's already so it has to do with establishing with the Committee on Investigation, and those are already established for a bishop or for clergy, but one is not already established for laity, and so you have to go ahead.
Yeah, and I feel like these are going to be more serious because it lays out right there. It says the pastor or presiding elder should take pastoral steps to resolve any complaints. So if it's gotten to this point, it's a pretty serious complaint. Like if it's not something that the pastor or the district superintendent can resolve and it's gotten to way up here, it's probably pretty serious.
It's either that or you've just got two very litigious parties that are not willing to reach peace with each other.
I guess that could be the case too.
Yeah.
So
it was a very rare thing in the United Methodist Church that a layperson was ever brought up on charges. It remains to be seen if...
Do you know any examples of that happening?
I think I said last week, I don't think they ever actually did it, but there was a U.S. politician that cited Romans chapter, isn't it 9, where it talks about the authority of the state to exercise the sword and as a justification for the death penalty. And so a lot of people...
They brought him up on charges?
Yeah, well, I don't remember if they actually did, but there was a lot of like angry things being written saying we need to pull him up on charges. We can do this in the Book of Discipline. So
interesting.
Yeah.
Okay.
Yeah, I should have looked that up. Anticipated that you would ask that question again.
Well, I was just curious because it just seemed like it would be a rare instance.
Yeah, but we have provision for it in the event that it's needed. All right, you ready to go on to paragraph 811?
Yeah, I think so. There's not anything that jumped out at you in that particular paragraph.
I mean, I would make the same joke that we made a couple weeks ago when it's saying these people should be of good character. Like, are we okay with people of bad character being on any of the committees? Like, but even so, I guess it's good to stipulate this.
Yeah.
All right, paragraph 811, referral of a complaint to a council for the church. Point 1, when the respondent is a bishop, point A, the chair of the TLC or their designee shall handle the supervisory response as per the JPP 4.2, which we will cover later. If a just resolution is not agreed to and the complaint is not dismissed, the chair or their designee may notify all active bishops and the relevant conference episcopacy committee, if any, of the existence and nature of the complaint and appoint counsel under JPP 6.1. Point B, if 6 or more members of the Committee on Investigation so recommend, the TLC may suspend the respondent with continuation of housing, salary, and benefits from all episcopal duties and responsibilities pending the conclusion of the trial process. All right, anything to say about any of that before we go on? That's just with the bishop.
Yeah, so if the complaints are made against a bishop, that's what happens.
Yeah.
Okay. I think I got that. If it hasn't gone through a just resolution, and they haven't dismissed it, and they've escalated it to the point where what do they call it? Committee on Investigation is involved. That's what happens. Okay,
let's go to what happens when
the respondent is a clergy person.
Actually, I found the article while you were getting clear.
About this politician?
Yeah, I'm going to put it up on the screen. It was Jeff Sessions. I don't know if you remember that name or not.
I remember him, but I don't remember.
There he was.
He does not look familiar.
More than 600 United Methodist clergy and laity say they are bringing church law charges against U.S. Attorney General Jeff Sessions, a fellow United Methodist, over a zero-tolerance U.S. Oh, I was wrong. It wasn't to do with capital punishment. It was to do with immigration.
Oh, yeah, separating children from their parents.
Yeah.
Which, let's not get into that. If you're, that's.
Aren't you glad I pulled that up?
The ignorance of people is just astounding. Like if you get arrested for drunk driving, of course you're going to be taken from your parents. If you enter the country illegally, of course you're going to get taken from your parents.
You really got triggered, man.
You
couldn't help it.
It's politics is triggering me. Okay, I'm done with that. That's okay. So Jeff Sessions, he's a Methodist.
6 years ago now.
Yeah,
but it still comes up a little bit.
It's interesting that he's a Methodist. I guess I don't. Hillary Clinton's a Methodist, and apparently he is too.
George Bush,
is he
W.
Really?
Yeah.
Wow.
You can be a Methodist, a United Methodist, and believe whatever you want.
Well, yeah. I mean, we see that all the time. Anyways,
All right,
let's
let's
go
get
on
back
before I
into
get
it. Yeah, I won't
off on
trigger
a
you again.
tangent.
All right, this is point 2. We're still in paragraph 811, dealing with a referral of a complaint to counsel for the church. So this is point 2 when the respondent is a clergy person. We just covered bishops, now it's clergy. Point A, if a just resolution is not agreed to and the complainant is not dismissed, the bishop shall notify the pastor-parish relations committee of the existence and nature of the complaint. Within 30 days, the bishop shall appoint an elder within the annual conference in which the alleged violation took place, who shall serve as counsel for the church under JPP 6.2. If 5 or more members, this is point B, if 5 or more members of the Committee on Investigation so recommend, the bishop may suspend the respondent with continuation of housing, salary, and benefits from all duties and responsibilities relating to their appointment pending the conclusion of the trial process. The respondent retains all rights and privileges as a member of the annual conference while suspended from pastoral duties, provided, however, they shall not interfere with an interim pastor appointed to carry out their duties while they are suspended.
Okay, so it's 5 or more in both of them, and there's 7 members of the committee. It's 4, was it 4 clergy? It was 4 professing members and 3 clergy.
There it is.
So 4 laity, I'm assuming,
Oh, sure.
because
Yes.
clergy are obviously professing members. So 4 clergy, 3 clergy, 4
And
laity.
then for lady.
Yeah.
Yeah. And then point 3, when the respondent is a layperson. So we've covered bishop, clergy, now layperson. Point A, if a just resolution is not agreed to and the complaint is not dismissed, the presiding elder shall within 30 days appoint a Global Methodist Church clergy or layperson to serve as counsel for the church under JPP 6.3. If 5 or more members of the Committee on Investigation so recommend, the pastor or presiding elder may suspend the respondent from exercising any church office pending the conclusion of the trial process. Okay. So if they are exercising any church office,
Right.
they can be suspended.
Yeah.
But they don't necessarily have to be. Although it would be weird if just some normal layperson with no authority had charges filed against them. But hypothetically, that can happen.
Mm-hmm.
But yeah, you'll have a Global Methodist Church inquisitor hired to investigate.
Yeah, we decided if Jeffrey was in charge, there would be an inquisitor.
Yeah.
A Global Methodist inquisitor who would be in charge of all of this, and we would just get it done, not waste time.
Yeah, like if you notice, and he's making it sound like it's a joke. It's not a joke to me.
He's completely serious.
There's so much waste in here. There's so much time from the time that the accusation is made till the final decision. There's so much money spent in, if these people are suspended, paying their wages and paying someone to fill in for them.
Right.
There's so much
If they have to
procedural.
travel, especially if it's a bishop, you got to pay for the bishop's travel.
Yeah.
The bishop's assuming board wherever they're at, like a hotel.
Yeah.
And if this drags on for 3 weeks, I mean, $100 a day for a hotel minimum.
So, and then the GMC is not going to be flush like the UMC.
Right.
And even if it is, it's reprehensible if we're spending all this money on trials, you know.
Well, what was we've talked about trials in the UMC, like how much they would cost. It was like upwards of,
It's always upwards of $1 million.
yeah, crazy amount of money
To
for
mobilize
one
that
trial.
money.
Yeah.
Now, I do think that this is less arduous than the United Methodist process. I think there's fewer people involved. So where there's like 7 people involved in the clergy thing, I think there's like 10 in the UMC. I don't know why I'm thinking that. I haven't read that in forever. But when you're looking at Carcaño's trial, that costs probably more than $2 million when all was said and done.
Well, yeah, she was suspended for how long with pay? So she couldn't
Year and
do
a half,
anything.
2
Yeah,
years.
she couldn't do anything the entire time, but she was still getting paid.
Yeah.
And
they get
that's-
paid a hefty salary.
Yeah. So,
Yeah, if you didn't see that coverage on Carcaño, I did a lot of it. So look back about 6 months ago when I covered each day of her trial and everything. So fun times. That chapter's behind us. All right, we're to paragraph 812, and I
Okay.
think it's your turn.
Committee on Investigation Procedures. 1 is introduction. The role of the Committee on Investigation is to conduct an investigation into the allegations made in the judicial complaint and to determine if responsible grounds exist to
Wait,
bring reasonable, not
yeah, there
responsible.
it is.
If reasonable grounds exist to bring a bill of charges and specifications to trial. Reasonable grounds is defined as sufficient reason based on the known facts to believe that a chargeable offense has been committed. If so, it shall prepare, sign, and certify a bill of charges and specifications. The committee's duty is only to determine whether reasonable, I don't know what is going on with me today. Reasonable. I'm reading the first half and the last half and completely like my brain is and
Don't worry
completely
about it.
leaving out
Yeah.
the middle. Reasonable grounds exist. Oh, I'm going to start that over. The committee's duty is only to determine whether reasonable grounds exist to support the charges. It is not the committee's duty to determine guilt or innocence.
Okay.
So
this is not a jury.
yeah,
This is just, are these silly charges or not?
but that's the point where it's gotten to the committee.
Yeah.
I guess in my head it was
So
they
you're
determined that beforehand.
No,
And then it was the jury, the committee's responsibility to determine, okay, are these legit or not? Are they actually guilty? Whose responsibility is it then?
they delegate a trial, a jury trial, pretty much.
Okay,
after
hold
this.
on. So they've got a preliminary thing that
Yeah.
does not involve the committee beforehand.
Yeah, it involves just one person receiving the complaint. I guess when it was a bishop, it was the head of the TLC. Whenever it's a clergy, then the bishop receives it. Whenever it's a laity, then the elder in charge receives it. Then they seek a just resolution. They can dismiss it, or they can kick it on up. And so if they don't dismiss, or what was the second one, figure out a just resolution or something
Right.
else to be done, then they kick it up to the committee on investigation, and then that committee determines if it is meritorious of a trial or not.
Okay, interesting. I wonder how, they didn't say how long they've got to do that.
I didn't see any time restrictions.
Okay. Let me read the last one. 2, the investigation process shall be administered according to the provisions of JPP 7. So
we'll circle back to that and see what kind of investigation they conduct.
yeah, that's interesting. I guess this seems more drawn out than I was expecting.
Yeah. Yeah. Well, so like when you're going to cross all your T's and dot all your I's, you got to have a multi-stage process involving lots of checks and balances.
Yeah.
But I've said it before and I'll say it again. It creates the appearance of justice, but the reality is that the people who prevail in court are people with the expendable time, energy, resources to navigate Byzantine processes. That's how power always works. So there's a specific reference in James to the rich being depraved because they are the ones who take you to court. So systems like this are always navigated by the powerful at the expense of the powerless.
No comment.
I should take back the always. I'm sure there are exceptions, but generally the powerful utilize whatever systems are in place for their own benefit. All right, we're at section 3 now, dealing with trials. So this is paragraph 813. General organization and pre-trial procedures. Point 1. Fundamental principles for trials. Church trials are to be regarded as an expedient of last resort. Only after every reasonable effort has been made to correct any wrong and adjust any existing difficulty should steps be taken to institute a trial. No such trial as herein provided shall be construed to deprive the respondent or the church of legal civil rights, except to the extent that immunity is provided, as in paragraph 805.9. All trials shall be conducted according to the Transitional Book of Doctrines and Discipline in a consistent Christian manner by a properly constituted court after due investigation. Trials shall be administered under the provisions of JPP 8 through 13. So what I noticed here that I didn't notice this morning when I was reading over this, that there is still, there are some like mediation courts. I've heard of like some Muslim ones or Jewish ones that actually see themselves as like superseding worldly courts. And whatever it doesn't matter what's in the Constitution or the state constitution, what we decide is what matters. And here, what I read this to be saying is, no, civil rights exist, and this court is not going to supersede a worldly court if a crime has been committed. That
makes sense.
Yeah. Okay. And then the rest was just providing an ethos of, we really don't want trials.
Yeah.
We have this whole structure for trials, but we don't want trials.
Yeah, last resort.
Yeah.
Let's not use it if we don't have to. Let's get it fixed before it gets to this point.
Yeah.
Which,
that'd be great.
Yeah.
All right. Go on.
814, convening of a trial court. Number 1, in the trial of a bishop, the chair of the Transitional Leadership Council shall proceed to convene the court under the provisions of JPP 9 and 11. 2, in the trial of a clergy, the bishop of the respondent shall proceed to convene the court under the provisions of JPP 9 and 12. And 3, in the trial of a lay leader, the presiding elder or district superintendent of the respondent shall proceed to convene the court under the provisions of JPP 9 and 13. So, if we're having a trial courts, if it's a bishop, the TLC lead chair is over it. If it's clergy, that clergy's bishop is over it. If it's a lay member, that person's presiding elder or district superintendent is over it.
There you go.
Or she'll start the court proceedings, I guess, is
Yeah.
convene the court under the provisions of. All of them are 9, bishops are 11, clergy's 12,
Yeah.
layperson's 13.
Very good. And yeah, we'll get to that in a couple weeks. All right, paragraph 815, the power of the trial court. Point 1, instruction, disqualification, voting, and verdicts. The trial court shall have full power to try the respondent. Period. The trial court shall be a continuing body until the final disposition of the charge. If any regular or alternate members of the trial court fails to attend any part of the session at which evidence is received or oral argument is made to the trial court by counsel, that person shall not thereafter be a member of the trial court, but the rest of the trial court may proceed to judgment. I didn't even think of stipulating that, but yeah, of course, that's good. If someone isn't there to consider some of the evidence, they shouldn't be part of making a decision.
Yeah. Okay. Yeah, that makes sense. There was something about that previously. I think we went over last week. If you don't show up, you can't just not show up to hold up the.
Yeah, that was a different thing, but it's similar. Yeah.
Yeah. Okay.
Yeah, this system does not benefit those who don't show up.
Right.
In a timely fashion. That's systemic racism right there.
Okay, this is the trial court shall have full power to try the respondent. So if somebody that is trying the person that the complaint's made against, if they don't show up, what does it say? The person shall not thereafter be a member of the trial court. So they're kicked out of that body.
Yeah, whatever the jury, whatever that is.
Yeah.
Yeah.
Okay.
They can't be a part of it.
That's interesting.
It's great.
No, I don't think there's a downside to that.
You can't have any flakes on the court.
Yeah. Okay.
Point 2, votes. A vote of at least 9 members of the trial court is required to sustain the charges, and 9 votes also shall be required for conviction. Have we gotten a total number on the trial court?
Is the trial court, it sounds like it's something different than the...
Yeah, this is the final body that actually renders a verdict.
But it's not the...
Committee on Investigation.
Yeah, it's not the Committee on Investigation. Because there were 7 people on that.
Yeah, the JPP document, I think, stipulates
that's
these
why
numbers,
we're not
and I'm going to assume it's 12.
Okay.
Because it mirrors... That's how many jurors are in an American justice system, right? 12?
I don't actually know that.
You're a bad American.
Yeah, I've never been brought to a... I've never had to do jury duty.
All right, look it up while I'm reading. All right, so unless the number of the trial court falls below 13. Oh, nope. Okay, so it's going to be greater than 13.
I guess 12 if you've got a half and half, then who would be the deciding vote? Well, it wouldn't even matter because you have to have 9.
Yeah, if you have to have 9 and that carries a majority, so then I would think that that's 15?
I don't know. 6 to 12 people is.
Oh,
yeah.
the American system is 6 to 12.
Yeah.
Okay. But we have more than that. Okay, look through the JPP document. Did you save that?
I can pull it up real quick.
Yeah, because I'm interested in how many are. Okay, but I'm going to read on. Fewer than 9 votes for conviction shall be considered an acquittal. In order to be sustained, the church must establish each specification and the charge by clear and convincing evidence. In order for evidence to be clear and convincing, the evidence provided to the trial court must demonstrate that the specification is highly and substantially more likely to be true than untrue. The trial court shall present to the presiding officer a decision on each charge and each individual specification under each charge. Its findings shall be final, but subject to appeal to the Committee on Appeals. So to me, that says it's not final, but maybe that just means you can't have any negotiation until you go through the appeals process.
Before you go on to JPP 9, trial convening and selection of the trial court. Point 2 is trial pool. It says at the appointed time, in the presence of the respondent, counsel for the respondent, counsel for the church, and the presiding officer, 13 members and 2 alternative members shall be selected as a trial court out of a pool of 35 or more persons selected.
Oh my gosh! So okay, you start with 13, and then fewer. Okay. A vote of at least 9 members of the trial court is required to sustain the charges, and 9 votes also required for conviction, unless the number of the trial court falls below 13, and in that case, 2/3 shall be required. Okay, so you start with 13, and
start with 13. You've got 2 alternates.
Oh, right.
Yeah. So
okay.
15, but the other 2 aren't going to be actually used unless there's some kind of.
Well, unless one drops out.
Right.
Yeah. Okay, that's interesting. I'm so glad you looked that up. Thank you.
Special consideration should also be given so that the pool includes persons representative of racial, ethnic, and gender
you knew it was
diversity.
going to be there.
Yeah,
you knew it was going to be there. So, so you have to if you don't get all 9 votes, say if you only get 7, which is still a majority, it's still considered an acquittal.
Yeah,
you get away with it, whatever you've done. So in the American judicial system, the phrase is guilty beyond a reasonable doubt, right?
For criminal charges, yeah.
Yeah. So here it doesn't utilize the same concept. It just says evidence provided to the trial court must demonstrate that the specification is highly and substantially more likely to be true than untrue. So it's not beyond a reasonable doubt. It's just like, it probably happened.
Yeah.
I'm a smart person. I think it probably happened.
Yeah.
If you get 9 people to vote that way, you're guilty. That feels weird to me.
I mean, I feel like any kind of jury trial is going to have its flaws. Like if it's I'm not going to bring up anything political.
Good luck.
If it's like a particular area that's the jury is comprised of, they might have a different way of thinking than some other place. Without, I'm not going to get into examples. It would
Too
be
vague.
Yeah. My point is, juries are going to have their biases, problems. It is what it is.
All right. That doesn't make me feel any better, but I'm glad you feel better. Yeah,
but you're in the opinion that like, okay, we've got one guy that's deciding all of this. It's up to that guy.
Yeah.
Kick him out if this guy decides.
Yes.
So now you've got 9 people at least instead of 1.
Great. Okay.
Yeah, I know you're not happy with it.
No, not. All right, let's go to penalties. If the trial results in conviction, this is point 3. Further testimony may be heard and arguments by counsel presented regarding what the penalty should be. The trial court shall determine the penalty, which shall require a vote of at least 7 members. If the number of the trial court falls below 13, a majority vote shall be required. So for the punishment, you only need 7 votes. Did I read this right? Whereas for conviction, you needed 9.
Say that again.
I'm just going to start from the beginning. Further testimony may be heard and arguments by counsel presented regarding what the penalty should be. So there's
So okay,
conviction and then
yes,
there's penalty.
yeah. So if 9 people determined that okay, this person is guilty,
Uh-huh.
then this is what happened.
Yeah, but it's only 7 people in this case. The trial court shall determine the penalty, which shall require a vote of at least 7 members. Or what? Yeah,
I think that's what it sounds like.
yeah. If the number of the trial court falls below 13, a majority shall be required. So 7 is a majority of 13. So you needed a supermajority for conviction, or greater than a majority, I don't know. And then you only need a simple majority for the punishment. That's interesting.
Yeah.
The trial court shall have the power to remove the respondent from professing membership, terminate the conference membership, and revoke the credentials of conference membership, ordination, or consecration of the respondent, suspend the respondent from the exercise of the functions of office, with or without pay if applicable, for a defined period of time, or fix a lesser penalty. The trial court shall determine whether a bishop or clergy person suspended from office as a penalty for a defined period of time shall have any continuation of housing, salary, and benefits during such suspension. The penalty fixed by the trial court shall take effect immediately, unless otherwise indicated by the trial court. Should any penalty fixed by a trial court be altered or reduced as a result of appellate process, the respondent shall be restored and or compensated as appropriate by the general church if a bishop, and by the annual conference if clergy, provided that in no instance and under no circumstance shall the respondent be entitled to receive an award of compensation for or reimbursement of any expenses or fees associated with the respondent's use of an attorney. That was a long final sentence there.
Yeah, it just seems like, okay, here's what the punishments or the penalties could be, is what I got from that.
Yeah, you can't like make them stand outside with a sandwich board on them saying, I am ashamed or something.
Yeah.
There's a limit to what punishments you can give. So, but I mean, you can fire him. You can.
Yeah.
But I wish they could be more creative in their punishments. They have to attend annual conference and just paint their face orange.
Oh yeah. It's just
for speaking badly about our ruler, President Donald Trump.
You said it.
I thought that was a hilarious thing to say. I'm so tickled at myself.
You get to sit at the front of annual conference. You have to do a voice, and you have to wear a wig.
Yeah, I get the sense nobody's going to be laughing in these settings. So, for people who didn't make the connection, the orange is Orange Man Bad Donald Trump. I do not call him my ruler. That was a joke. Don't get triggered. All right. We are now at section 4, which deals with appeals. So, of course, once you've gone through this whole process, it's still not over.
Mm-hmm.
You can appeal it. So, read to us.
Well, assuming that you're found guilty.
Yeah.
If you're found guilty, you want to appeal it. So, I mean, I guess that makes sense. You're not for appeals.
No. I'm for summary judgment by one guy.
True, yeah.
I mean, this is
so
like
this is
prolonging things so much more, getting more money spent, more people involved.
True. I wonder how many appeals they get. I guess we'll find out. Paragraph 8:16. Appeal procedures - general. 1. In all cases of appeal, the appellant shall be given written notice of appeal within 30 days.
They shall give the written notice.
Oh, they shall give. Okay, so
Yeah,
they've got.
They're not going to receive it. They're going to give the
that
written
makes
notice.
sense.
Yeah.
Notice of appeal within 30 days of the verdict and announcement of penalty by the trial court or the issuance of a written decision of the appellate body other than the connectional counsel of appeal on appeals. Okay, so I want an appeal. I've got 30 days to do it.
Yep.
After they decide it.
Mm-hmm.
Okay. At the same time, the appellant shall furnish to the officer receiving such notice, JPP 14.2, and to the counsel for the opposing party a written statement on the grounds of the appeal. The hearing in the appellate body shall be limited to the grounds set forth in such statement. Okay. 2. When the appellate body shall reverse in whole or in part the findings of a committee on investigation or trial court, or remand the case for a new hearing or trial, or change the penalty imposed by the trial court, it shall return to the convening officer a statement of the grounds of its action, which shall also be copied to the respondent, complainant, and counsel for the church.
So they can overturn the whole trial, and they just have to write a letter to the original guy or gal in charge.
So this is if they've actually appealed it, or if they've
If it's been appealed and
considered the
they have
appeal?
considered the appeal, yeah. They've already limited, they can't reconsider everything under the sun. There are specific things that the case apparently turns on that they will consider and then issue a finding.
Okay. 3, an appeal shall not be allowed in any case in which the respondent has failed or refused to be present in person or by counsel at the investigation and the trial. Appeal shall be heard by the proper appellate body unless it shall appear to the said body that the appellant has forfeited the right to appeal by misconduct, such as refusal to abide by the findings of the trial court, or by withdrawal from the church, or by failure to appear in person or by counsel to prosecute the appeal, or prior to the final decision on appeal from conviction by resorting to such in the civil courts against...
Resorting to suit in the civil courts.
by resorting to suit in the civil courts against the complainant for any of the parties connected with the ecclesiastical court in which the appellant was tried. That's a lot.
Yeah, that's a lot of words, man.
Okay, so if you don't show up, you don't get to appeal.
If you don't show up, if you have ceased being a Global Methodist, if you've left the denomination.
Yeah, if you don't abide by the findings of the court,
Yep.
you don't get to appeal.
Mm-hmm.
If your counsel doesn't show up, if you don't show up and your counsel doesn't show up, you still don't get the
You're
appeal.
out. Yeah. Quit wasting our time.
Does that say by resorting to suit in civil courts against the complainant? So if they file charges in civil court,
You've now escalated things.
Yeah, so then you don't get an appeal.
No.
I guess that makes sense.
Yeah.
Okay. All right. 4, the right of appeal, when once forfeited by neglect or otherwise, cannot be revived by any subsequent appellate body. So if you, for whatever reason, for all of those previous reasons, you basically can't appeal again.
It doesn't matter how right your cause was or anything.
Yeah, you get one time.
Yeah, a 30-day period. Yeah.
Okay. 5, the right to prosecute an appeal shall not be affected by the death of the person entitled to such a right. Heirs or legal representatives may prosecute such an appeal as the appellant would be entitled to do if living. Okay, so you can die.
Yeah, your family can still seek justice. They can seek to clear your name.
I guess that makes sense.
Mm-hmm.
Okay.
Yeah, they keep a permanent record on you, and they can announce that you left under bad circumstances. So
yeah,
if you want that rectified, your heirs can continue that fight on your behalf.
Interesting. 6, the records and documentation of the trial, including the evidence, and these only shall be used in the hearing of any appeal. Okay, so you don't get to introduce any new evidence?
No, I don't think so.
That's interesting. Because I'm thinking like, okay,
if there
what
was
if something...
like new security camera footage available?
Yeah, you don't get to use that.
Yeah.
Even if it clears your name.
I think that's the case in American civil law too, though.
Maybe in civil, yeah. I guess that would... Definitely not in jury. Or not jury,
Criminal?
Criminal.
Really?
Yeah, I wouldn't think so. If there's
you can introduce new information on an appeal? Lawyers.
I don't know, yeah.
Lawyers, write in. I'm curious. We're curious. If PlainSpokenPod@gmail.com.
Well, I mean, think about it. If you're convicted of like murder or something, and new DNA evidence comes up, you can appeal on that.
I think you can have a mistrial called.
I don't think so. So I'm thinking like what is that? What is that Netflix?
To Catch a Killer.
No.
To Miss a
Making a
Murderer.
Murderer.
There
Making
it
a
is.
Murderer.
Yeah.
I was really into that when it came out. But his first conviction, DNA evidence. He was in jail for 15 years, something like that. I don't remember exact terms. But DNA evidence came up because they didn't have DNA evidence
Back in the day.
in the day, yeah. And it cleared him on that. So they appealed the decision, the ruling.
There's not a period of when an appeal will expire. There's not what's it called? A something on appeals, a limit on appeals.
Yeah, I don't think so.
But yeah, so that wasn't what we were talking about, though. We were talking about, can you introduce new evidence? And at least in that case, you could.
Yeah.
Okay.
Which would be a criminal case, which this is obviously not. Well, yeah, no, if it's a criminal case,
it's going to go to civil court.
Yeah. Well, it's going to go to criminal court.
Yeah.
So
worldly criminal. Okay.
Okay. We're getting off in the weeds. 7. The appellate body shall determine 2 questions only. Question 1 is A. Were the charges sustained by clear and convincing evidence? Okay. B. Were there such errors of church law as to
vitiate?
That
means fall apart.
Makes sense, yeah.
Yeah.
Vitiate the verdict and or the penalty. These questions shall be determined from the records of the trial. The appellate body shall in no case hear witnesses, but shall receive and or hear arguments of the counsel for the church and the respondent. It may have legal counsel present, who shall not be the conference chancellor for the conference from which the appeal is taken, for the sole purpose of providing advice to the appellate body.
So they will not hear witnesses. They'll just get addressed by the counsel for the church and the respondent.
So 7, shall be, the appellate body shall determine 2 questions only. I feel like A, were the charges sustained by clear and convincing evidence? If they say, yeah, that was clear and convincing evidence at the time, but I mean, we can't introduce any new evidence, then why would the appeal even take place?
If you want to allege that the jury pool was somehow like compromised or biased and was out to get you or something, just to have another party outside of your area looking at it and confirming that that was the case or not.
Maybe. I don't know. I guess I would have to see other examples of it, of like stuff that would actually take place. And in order to do that, there's going to have to be transparency, because if nobody knows about it, then whatever. Anyways, well, let's go on to 8.
Well, did you get point B?
Yeah. I had read
okay.
before.
Okay.
So we'd gotten through that.
Okay.
8. In all cases where an appeal is made and admitted by the appellate committee, after the charges, findings, and evidence have been read and the arguments concluded, the parties shall withdraw and the appellate committee shall consider and decide the case. It may reverse in whole or in part the findings of the committee on investigation or the trial court, or it may remand the case for a new trial to determine verdict and or penalty. It may determine what penalty, not higher than that affixed at the hearing or trial, may be imposed.
So you can't have a situation where they appeal and you go, actually, you're even guiltier than they understood. We're going to require you to have orange face and a wig all, and you can't like make the penalty higher based on, or you're wasting our time. We're going to punish you even more. You can't do that. So you can, at the worst, you can only stand by the punishment they already got.
Okay. That makes sense. Remand the case for a new trial to determine. Okay, so if any new penalty or verdict is needed, they'll send it back to a new court.
Oh, yeah,
trial.
they can have a whole other trial if they're like, y'all did a really bad job on this one.
It's
Yeah,
a whole new trial.
yeah. They
Okay.
can do that.
Yeah. If it neither reverses in whole or in part the judgment of the trial. So it can reverse part of it. Or the whole
It can do
thing.
whatever it wants, yeah.
Okay. Nor remands the case for a new trial, nor modifies the penalty. That judgment shall stand, subject to possible appeal to the Connectional Council on Appeals. So there's a whole nother appeal process besides that to the Connectional Council on Appeals.
There you go.
Okay. The appellate committee shall not reverse the judgment nor remand the case for a new hearing or trial on account of errors plainly not affecting the result. All decisions of the appellate committee shall require a majority vote. Okay.
So even if they did or said some stupid things in the original trial, if it didn't really impact anything, you can't just have the whole thing dismissed or disqualified if it wasn't substantial. And
yeah, I guess in my brain, I'm trying to think of examples where this would happen, and unless I've got an example, it's hard for my brain to connect it.
Yeah.
Okay, 9. In all cases, the right to present evidence shall be exhausted when the case has been heard once on its merits in the trial court. But questions of church law may be carried on appeal step by step to the Connectional Council on Appeals, which is paragraph 824.8 and 9. I feel like I need to go to school for law.
this is your school, son.
Yeah,
Right here.
So.
Yeah.
I
reached out and figured out there are 3 primary authors of the JPP document, and I think of this section as well. Chapel Temple, who I recently interviewed, and a lot of people like that interview, so you should check it out. But also Tom Lambrecht and Jay Therrell. And so at least 2 of those have law degrees. And so, yeah, this is definitely crafted by legal experts.
It's good.
Yeah.
10. The church shall have no right of appeal from findings of fact of the trial court. So the court can't appeal, or the church can't appeal. The church shall have a right of appeal to the Committee on Appeals and then to the Connectional Council on Appeals from findings of the Committee on Investigation or trial courts based on egregious errors of church law or administration that could reasonably have affected its findings. In this paragraph, egregious errors of church law or administration refers to the misunderstanding, misinterpretation, misapplication, or violation, whether knowing or not, of church law or judicial process as required by the Transitional Book of Doctrines and Discipline, with such errors more likely than not in the judgment of the appellate body, affecting the findings of the trial courts or Committee on Investigation. The Committee on Investigation's decision not to certify a bill of charges does not alone constitute an egregious error of church law or administration. When the Committee on Appeals shall find egregious errors of church law or administration under this part, it may remand the case for a new hearing or trial on verdict and or penalty, in which event it shall return to the chair of the Committee on Investigation or presiding officer of the trial court a statement of the grounds of its actions. This action is not to be considered double jeopardy. Can you translate that for me?
I think so. It starts off saying that the church doesn't have a right of appeal.
Right.
So if they didn't get a guilty verdict and they wanted one, they can't just try you again.
Which
that would be
makes
double
sense.
jeopardy.
Yeah.
Pretty much. And then when the Committee on Appeals shall find egregious errors, it may, I think I just hear it saying it still has the authority to do whatever it wants. It's just the church doesn't have the authority to do whatever it wants.
Yeah, you can't just have the church appealing every time there's a new bishop that thinks this person was guilty.
Mm-hmm.
Okay. Well, they said at the end, this action is not considered double jeopardy. That's when,
The same person is tried twice for the same crime on the same evidence.
right. I'm trying to, what was the stipulations of that? When does that not consider double jeopardy? When the Committee on Appeals shall find egregious errors of church law or administration under this part, it may remand the case for a new hearing or trial verdict. So if the Connectional Council on Appeals finds out that, hey, these violated the Transitional Book of Doctrines and Disciplines, let's charge them again, then it's not considered double jeopardy? Is that how?
I think it's
am I
more
reading that
like,
right?
hey, turns out they were like, the church was paying people to render this verdict or this judgment.
Mhm.
We can trace the paper trail. Like, that's obviously a mishandling of justice.
Right.
So we need to do it again. I think.
Well, that would be the case. The church is not up for trial at that point.
It's not what?
It's not up for trial. Like they're not the ones being. They're not under investigation. They're not the
No,
respondent.
they would be like the complainant. I think.
Right, but there's no double jeopardy because there's no case that the church would be the respondent. It's always going to be a person within the church.
Yeah.
So
you
if the
can't
bishop
bring the
was
whole
paying-
GMC up on charges.
Yeah, if the bishop was paying people to. I don't know. Yeah, I don't know.
It's just
I'd have to
it's
think of-
constituting were there egregious errors in how this was all done,
Right.
such that it's not even really properly considered a court. It was just a kangaroo court. Then it reserves the right to mandate another trial.
Man, I'm gonna have to go back to college for this.
Let's finish this section.
11. Questions of procedure may be raised with the presiding officer or secretary of the appellate body when the answers shared with all parties. Under no circumstance shall one party, in the absence of the other party, discuss substantive matters with members of the appellate body while the case is pending, which is paragraphs 805.5 and 805.6.
And that precedent has already been set anyway. If you're going to have a proper procedure,
Everybody's got to be there.
Yeah.
Okay. Yeah. 12. The appeal of a bishop or clergy member shall be administered according to the provisions of JPP 14. 13. The appeal of a lay member shall be administered according to the provisions of JPP 15.
So that's the whole process from filing the complaint, it being reviewed by the initial person, recommended on to committee of investigations, recommended on to the jury pool. I might have forgotten a title in there. But yeah, many steps, many different directions it can go. And at the end, aren't you just so confident that justice has been served?
I don't know. I'm sure there's reasons for all of this in here.
Absolutely.
So
yeah, the people who wrote it are smarter than me and you.
Yeah. I have
Okay.
nothing else to say on that one because I don't really understand it completely.
Let's carry this forward just a little bit more. The next section isn't very intense. It's appeals of questions of law. So this is paragraph 817. Point 1, the order of appeals on questions of law shall be as follows. So this is not dealing with a court case has happened, we're asking an appeal on the verdict. It's rather what laws we have in the books, making an appeal on that. We should question whether or not our laws fit other laws in our book. A, from the decision of the presiding elder presiding in the charge or district conference to the bishop presiding in the annual conference and then to the connectional council on appeals. B, this is the order. So B, from the decision of the bishop presiding in the annual conference to the connectional council on appeals. C, from the bishop presiding in a regional conference to the connectional council on appeals. And D, from the bishop presiding in the general conference to the connectional council on appeals. So those are all the different pathways that this appeal can take to be brought and properly considered.
Okay.
Point 2, when a question of law is raised in writing during a session of a conference, it shall be the secretary's duty to see that an exact statement of the question submitted and the ruling of the chair thereon shall be entered on the journal and minutes of the conference. The secretary shall then make and certify a copy of the question and ruling and transmit the same to the person or body to which an appeal is taken. So it happens all the time that a decision is made on the floor of annual conference that somebody's like, I don't know if that's legal according to the way that we've written up our book of discipline. And so we're going to make an appeal of the ruling of the chair that then in the United Methodist Church would be reviewed by the Judicial Council. It's the Connectional Council on Appeals that would review it in this case.
Okay.
Yeah. TJ likes this. Okay.
I'm
Okay.
lost.
So the next section is, I want to finish this, and I'll just read through the page. It's paragraph 818, Appeal of Administrative Decisions. So this also references paragraph 806. Point 1, the order of appeals on procedures in an administrative process shall be as follows. A, from the decision of the Board of Ministry Investigative Committee to the Annual Conference Administrative Review Committee. I'm just letting everybody see your face while you're just really enjoying this. B, from the Administrative Review Committee to the full Board of Ministry. And C, from the full Board of Ministry to the clergy session. So that's the pathway that this can take. D, questions of law arising from an administrative process should be raised in the clergy session for ruling by the bishop and review by the Connectional Council on Appeals. So that we've heard this several times, Connectional Council on Appeals. I'm pretty sure that this is the Judicial Council for the GMC, I think. Point 2, in all cases of such an appeal, the appellant shall within 30 days give written notice of an appeal and at the same time furnish to the officer receiving such notice a written statement of the grounds of appeal, and the hearing in the appellate body shall be limited to the grounds set forth in such a statement. So it can't turn into a conflagration of everything wrong. You've confined it to just one specific issue you need to appeal. Point 3, the appellate body shall return to the convening officer of the administrative hearing and to the appellant a written statement of the grounds of its action, which shall also be placed in the appellant's personnel file. So there's a file kept on everybody that someone who has a problem, it goes into their file. We got a paper trail here. Point 4, an appeal shall not be allowed in any case in which the respondent has failed or refused to be present in person or by counsel during the administrative hearing. Appeals shall be heard by the proper appellate body unless it shall appear to the said body that the appellant has forfeited the right to appeal by misconduct, by withdrawal from the church, by failure to appear in person, or by counsel to prosecute the appeal, or prior to the final decision on appeal by restoring to suit in the civil courts, by resorting to suit in the civil courts against any of the parties connected with the ecclesiastical administrative process. So we've already covered this. If they don't show up to press their case, the case gets dropped. If it escalates to a civil court, the case gets dropped. It's just making clear. Point 5, the right to appeal when once forfeited by neglect or otherwise cannot be revived by any subsequent appellate body. Point 6, the right to prosecute an appeal shall not be affected by the death of the person entitled to such right. Heirs of legal representatives may prosecute such appeal as the appellant would be entitled to do if living. We've also covered that in today's session. 7, the records and documents of the administrative process, including any evidence, and these only shall be used in the hearing of any appeal. Similarly, we've covered this. Point 8, the appellate body shall determine one question only, whether such errors of church law or procedure as to vitiate the recommendation and or action of the administrative body, the records of the administrative process, and the arguments of the official representatives of all parties shall determine this question. The appellate body shall in no case hear witnesses. It may have legal counsel present for the sole purpose of providing advice to the appellate body. You happy?
I mean, a lot of these are just repeats of the ones before.
Yeah, they've established these principles.
This is in the case of an administration appeal of administration. Appeal of administrative decisions as opposed to appeal by the person that charges are brought against?
Yeah, so we've had
That-
an appeal in a what would be equivalent of a criminal trial, sort of, and then you have appeal of questions of law, and then you have appeal of administrative decisions. So there are different kinds
So,
of appeals.
okay, so I get charged by the church for something. I think it's wrong. I can appeal the decision. These are the types of appeals that I can put forward.
I think that makes sense. Yeah.
Okay.
Well, but there doesn't have to have been a case in the first place. Like in the event that a bad call is made on the floor of annual conference and you're appealing the decision of the chair, there was not a church trial for you to then appeal the decision of. There was just a proceeding of annual conference for you to appeal the decision of. So it's
Okay, so these are not necessarily for trials, is
right.
what you're saying.
Yes.
Okay.
Yeah.
Okay. I
But
guess that makes
the
sense.
language in this administrative decision section is suggesting to me that there was a trial, and it's being appealed in some sense because
Okay.
they're talking about calling witnesses and presenting new evidence and all this stuff that we've already done.
Right.
So I'm not altogether clear the distinction between this and the appeals process after a trial has been done. It's kind of opaque to me still.
Okay. Same.
Yeah. All right. I think we were on point 9.
Yeah, 9.
If the appellate body determines that any error has occurred, it may recommend to the appropriate person or body that action be taken promptly to remedy the error, decide the error is harmless, or take other action. The appellate committee shall not reverse the judgment nor remand the case for a new hearing on account of error plainly not affecting the result. All decisions of the appellate committee shall require a majority vote. Once again, a lot of repetition of what
Right.
we've already covered. Point 10, in all cases, the right to present evidence shall be exhausted when the case has been heard once on its merits in the proper administrative hearing body, but the decision of the administrative hearing body may be appealed as outlined in paragraph 819.1. Questions of church law may be raised in the clergy session and carried on appeal to the Connectional Council on Appeals. So I'm thinking that a verdict wasn't rendered by an assembled court, but by an administrative body. For some reason, they've rendered a decision. It's not on the floor of annual conference. It's some other administrative body, and you're appealing what they concluded. I'm thinking that's what makes sense out of this. Okay.
Okay. Yeah. No, I'm a little bit lost. It's a lot to take in.
Yeah.
So I'm not following all of it, but I'm glad that you are.
I'm pretending. All right, final point for today, point 11. Questions of procedure may be raised with the presiding officer or secretary of the appellate body with the answers shared with all parties. Under no circumstances shall one party in the absence of the other party discuss substantive matters with members of the appellate body while the case is pending. And we've already covered those principles as well. So we've covered a lot of ground today. We're going to cover as much next week, and then we'll be done with this section in the Transitional Book of Doctrines and Discipline. But then after that, we'll come back to the JPP document. I might see if I can get an interview with Lambrecht or Therrell or Temple, see if they can give their impressions of the most important stuff. But I think you did all right. You dug in more than a lot of people would.
I mean, the first part of it made sense to me. I'm not connecting the dots. It's for some of the other ones, and I'm getting hung up on that, and that's just how my brain works. So.
Well, and it's a lot of people don't understand. I mean, for the authors of this, they understood the different behind-the-scenes structures and administrative stuff that is built, and we've walked through that, but still, like, we haven't put in the time and energy that the original authors did to envision how all these different moving pieces will function together and how that dysfunction will be corrected, or at least create the impression of being subject to correction in the appeals process here. So anyway, we need to go ahead and wrap this up. So if you have thoughts on the job that we've done and you have it in you to be kind about our failures, then go ahead and write us. The comments are particularly helpful because other people can engage those comments, and generally speaking, my commentators are not really nasty. So consider putting in writing things that you think we didn't understand. Help us connect dots, and that would be really appreciated. Stay along for the ride with us because come September, so One of the things I've heard said is it's going to be a limited general conference because there's no way they're going to be able to consider the whole book. I talked to Karen
Mm.
Nicholas about this, and she said, I think the whole book is going to be considered. So I've heard different things. Chap Temple said one thing, she said another, and then I forget where the third. I want to say it was an article by Walter Fenton. No, it was with the publication of this new document by Beth Ann Cook. Apparently, it stipulates what items are going to come to the floor and what items are not.
Beth Ann Cook. I know that name. What does she do?
She's been at the head of a lot of United Methodist delegations leadership for some time, and now she's with the GMC, and she's chairing that committee on putting the convening conference together. She's a go-getter.
Okay.
Yeah.
I don't know. That name came up, and I don't know enough about it to. Anyways.
Yes, hers is a name that people following
Right.
should know. So.
Okay.
Anyway, we're going to do our best. It's not going to be good enough, but the hope that we have, what we're aiming at, what I think we can do is provide a clearer picture of what's going on for people who are along for the ride with us, and so that whenever our convening conference gets together, it's not a bunch of people that just do their best last minute, but it'll be people who really know what's going on. So to that end, make sure that as your conference selects delegates, that they are invited to follow along with us through this series, because it'll help them make good decisions. You made a good decision by spending time with us. You are now dismissed. We'll see you next week.